a term and a half before I got here, so I had the opportunity of serving with him for my entire tenure on this great committee. It's interesting that before joining Congress, Representative Grijalva practiced what he preached to us over and over again. He served as a school board member in Tucson for 8 years, where he advocated for access to education for all students, but especially underserved communities. And then in the workforce area, he was a champion for workers, and demonstrated why this was a committee he chose to serve on for his entire tenure. I greatly respected his commitment to serving the nation, serving his district, his community, his purposes. He will be dearly missed on this committee, and I hope his friends and loved ones can find comfort in the legacy that he has left behind. And so, Mr. Chairman, thank you for allowing me the privilege to recognize a good member for the work that he did. Thank you. I yield back.
Thank you, Chairman Walberg. Ranking Member Scott, you are recognized for as much time as you may consume.
Thank you, and I want to associate myself with the comments of the chairman. We're deeply saddened to learn of the passing of our friend and colleague, Raul Grijalva. Raul and I sat next to each other for many years on this committee, and we could always rely on him for a sense of optimism and humor during some of the toughest legislative fights. In addition to being a talented doodler, he was a champion for his constituents. He was a fierce defender of unions and civil rights in the workplace. On the committee, he was the lead sponsor, fighting for legislation to fight heat illness, which would help protect indoor and outdoor workers from occupational exposure to excessive heat. He was an advocate for universal education, regardless of immigration status, and he pushed to expand funding for English as a second language. And along with the late Donald McEachin, he was a champion on his other committee for environmental justice. He will be deeply missed, not only as a colleague, but also as a friend and advocate. And so we send our deepest condolences to his family, staff, and everyone impacted by his loss. Mr. Chairman, thank you for the opportunity to speak, and I yield back.
Thank you, Ranking Member Scott, and I would also like to express my condolences to the family and friends of the departed representative, a great member of our House, and he and his presence here will sorely be missed. Now we'll continue with the hearing, and today's hearing we're going to be examining the critical reforms to modernize labor law in the United States of America. We are seeking to bring more clarity to workers and employers, and today's hearing will be discussing what I hope is the bipartisan goal of bringing a much-needed update to our federal statutes and bringing them into the 21st century. As the foundation of our nation's wage and hour protections, the Fair Labor Standard Act covers employees at nearly every workplace across the country, totaling about 140 million individuals. The American workforce has transformed dramatically since the law was adopted 87 years ago, but many of the workplace laws and policies have not been updated. We saw during the last administration, unfortunately, even more onerous burden being placed on workplaces and workers all across our country. They were forced into complying with many of these burdensome regulations that stifled innovation and set arbitrary standards, some of which even violated the Administrative Procedure Act, the cornerstone governing many federal agencies that issue regulations. For instance, the Biden-Harris administration's unlawful overtime rule attempted to raise the salary threshold to be considered an exempt employee under the FLSA by a whopping 65%, with automatic increases every 3 years. This rule threatened to restrict workplaces, limit professional development opportunities, and eliminate the flexible advantages exempt employees have. Moreover, the rule was estimated that it was going to be a significant cost to employers and actually, in many ways, disadvantage the very employees that they were seeking to help. While we also saw the Department of Labor under President Biden issue an unworkable, confusing ABC-style worker misclassification test to determine which workers are employees and which are independent contractors. This rule limits the ability of as many as 70 million freelancers, rideshare drivers, and other independent workers to earn a living on terms that they set for themselves. The last 4 years, again, we've seen this excessive administrative ruling also continue for tipped workers. Tipped workers can perform their duties and provide great services all across our country for so many people, but at the same time, the limiting restraints that were placed on them only allowed them to do tasks for 20% of an employee's workday, which is essentially impossible to monitor and enforce. Rules like this raise the question, if the government cannot enforce its own standard, what is the purpose of even setting it? Finally, we saw the Wage and Hour Division abandon the Trump administration's payroll audit independent determination program. This was something that was actually helping workers. We found that employees who had unknowingly, in some cases, committed a violation, reporting themselves, and then bringing this forward, making sure that back pay and overtime violations were corrected, getting that money to workers faster. But the Biden Department of Labor unwisely decided to end this program and instead focus their energy on cracking down on lawful job creators. Thankfully, Americans chose change last November, and they are starting already to see relief from this Trump administration as they work to undo many of these terrible mandates that were placed on employers all across our country. Now, I think we also have an opportunity as a committee. Members of our committee and also throughout the entire House have offered so many positive changes that can help employers and employees as we try to update FLSA. I would like to thank all of those who have brought forward their ideas, and among many items for us to consider at today's hearing are simple changes that modernize FLSA, such as evaluating the methodology for overtime regular rate calculations, which often discourage employers who wish to offer child care benefits to their employees. Today, we will hear from witnesses about how non-exempt workers are often not given the same voluntary professional development opportunities as exempt workers because of FLSA's definition of compensable time. And finally, we will discuss how employee status and independent contractor status should be clearly and concisely defined under the common law standard. I look forward to hearing our witnesses and yield to the ranking member for her opening statement.
Thank you, Mr. Chairman. Good morning, everyone. Thank you to our witnesses for being here today. Mr. Chairman, congratulations on your position, and I look forward to working with you on this subcommittee. I hope you'll indulge me for a moment. It is an honor to serve as the ranking Democrat, not only because of the important work that we are going to do overseeing our nation's labor laws, but because I am following in the footsteps of one of my political heroes, the late Senator Paul Wellstone of Minnesota. Senator Wellstone served as the ranking member of our Senate subcommittee counterpart, and in 1997, his first opening statement in that role was on this very topic, the Fair Labor Standards Act. Today, as we discuss this landmark law, I hope that we will do it with the same commitment to uphold fairness and strengthen worker protection and prioritize the well-being of the working people. Now, let's be honest about what's happening in our country. Millions of workers wake up every morning, put in long hours, and still struggle to make ends meet. Meanwhile, billionaires and CEOs are making record profits off their labor. For too long, our economy has only worked for the wealthy and the well-connected, while workers have been left behind. Over the past 4 years, the Biden administration and congressional Democrats fought to level the playing field, but now that progress is under attack. Since returning to the White House, President Trump has wasted no time implementing Project 2025 to attack workers, ripping away protections, dismantling labor enforcement, and handing over more power to the same corporate interests that have exploited workers for decades. The future of the American economy depends on American workers. Yet today, economic inequality is reaching levels not seen since the 1920s. The Fair Labor Standards Act of 1938 was created as a reaction to that inequality and the Great Depression, when workers lacked basic workplace protection. That is why we must strengthen this landmark law, not weaken it. That means finally raising the federal minimum wage, which has been stuck at a shameful $7.25 an hour since 2009. It means tackling wage theft, because every year employers steal over $50 billion from workers' pockets. It means increasing penalties for child labor violations. It means eliminating sub-minimum wage and the 14C so that workers with disabilities are paid fairly like everyone else. There is so much we can and should be doing. I hope that is the kind of conversation that we will be having today, Mr. Chairman. I hope this hearing is not just the latest in a long line of Republican-led efforts to undermine the FLSA under the guise of updating it. Last month, Ranking Member Scott and I wrote a letter to the Department of Labor demanding to know the impact of DOJ's takeover and firing of countless staff at a critical DOL program, such as the Wage and Hour Division, which enforces the FLSA. Trump's DOL failed to respond by the March 14th deadline, leaving Congress and working Americans in the dark about the future of these programs. I invite Chairman McKenzie and my Republican colleagues to join us in demanding answers on behalf of our constituents. I would like to submit this letter into the record.
Without objection.
Democrats are providing concrete solutions to safeguarding workers during these difficult times and looking to build an economy for the future instead of dragging our country backwards. We want workers to come home safe and be paid fairly for their labor. We want children in the classrooms, not in the factory floor. We want to raise the minimum wage so that no one is in poverty while working a full-time. These goals should not be controversial. This is why we must pass key legislation such as Raise the Wage Act, which would increase the minimum wage, and the Let's Protect Workers Act, which would hold employers accountable for breaking the law. As we sit here today, thousands of federal workers across the country, such as medical personnel, scientists, park rangers, face losing their livelihoods and the ability to support their families, while the American public stands to lose essential services they provide. Workers deserve better. America deserves better. Thank you, and I yield back.
Thank you. Pursuant to Committee Rule 8C, all members who wish to insert written statements into the record may do so by submitting them to the committee electronically, the committee clerk electronically, in Microsoft Word format by 5 p.m., 14 days after the hearing. And without objection, the hearing record will remain open for 14 days to allow such statements and other extraneous material noted during the hearing to be submitted for the official hearing record. I note that the subcommittee has some of my colleagues who are permanent members, or they're not permanent members of the subcommittee, but they may be waiving on for the purpose of today's hearing. All right, to begin with our witnesses, I'd like to thank all of you for joining us here today, and we're going to introduce each of you. The first witness is Ms. Tammy McCutcheon, a senior affiliate for Resolution Economics in Newmarket, Tennessee. Our second witness is Ms. Paige Bohan, who is a Senior Vice President and Director of Human Resources for Farmers and Merchants Bank in Hampstead, Maryland, and is testifying on behalf of the Society of Human Resource Management. Our third witness is Mr. Andrew Stetner, who is the Director of Economy and Jobs for the Century Foundation in Washington, D.C., and our final witness is Mr. Jonathan Wolfson, who is the Chief Legal Officer and Policy Director for the Cicero Institute in Richmond, Virginia. We thank the witnesses again for being here today, and we look forward to each of your testimony. Pursuant to the committee rules, I would ask that you each limit your oral presentation to a 3-minute summary of your written statement. The clock will count down from 3 minutes as committee members have many questions for all of you, and we would like to spend as much time as possible on questions. Pursuant to Committee Rule 8D and committee practice, however, we will not cut off the testimony until you reach the 5-minute mark. I'd like to remind the witnesses to be aware of their responsibility to provide accurate information to the subcommittee, and I will first recognize Ms. McCutcheon for your testimony.
Thank you for inviting me to speak with you today. I have made specific recommendations for FLSA reform in my written testimony. I suggest all of these with 3 principles in mind. First, the FLSA is out of date. Key sections have been unchanged for 3/4 of a century or more. Although the type of work, how we work, and where we work has changed significantly in that time. Second, we need clear and simple rules that workers and small business owners can understand without an HR professional or an attorney. Third, justice delayed is justice denied. Workers can't wait months or years for their wages. They need them now. The greatest need for reform, I think, comes in 4 areas. First, the definitions. The FLSA requires employers to pay employees for work. Employers, employees, and work. But the definitions of these terms are so vague and circular as to be useless. DOL's regulations run to 10,000 words. Is it surprising that we have been debating joint employment and independent contractor for nearly a decade? Millions spent on litigation, thousands of court and agency cases, dueling regulations from one administration to the next. Only Congress can stop the madness. Second, the overtime calculation. Most believe that overtime is 1.5 times the hourly rate. Wrong. It's 1.5 times your regular rate. Regular rate was defined in the 1949 amendments as all remuneration for employment with 7 exclusions: gifts, some bonuses, some benefits. Except for adding stock options in the year 2000, these have not been changed for 76 years. DOL regulations, 43,000 words. So long and complex, how can we expect workers and small business owners to get the right answers? Congress could simplify and benefit workers greatly by amending Section 7E to exclude non-monetary benefits provided to employees regardless of the hours that they work. Then an employer could give workers free meals, free public transit, childcare, college tuition, even repayment of student loans without fear of unplanned and uncontrolled overtime costs. The last 2 areas for reform are overtime exemptions and providing incentives to employees to self-audit. I see my time is up, so I will end here. Thank you.
Thank you. I appreciate that strict adherence to the timing. I'll now recognize Ms. Bohan for your testimony.
Chairman McKenzie, Ranking Member Omar, and subcommittee members, thank you for the opportunity to testify about the Fair Labor State Council Legislative Director for Maryland, SHRM. SHRM, made up of nearly 340,000 members, is the foremost expert, researcher, advocate, and thought leader on issues impacting today's evolving workplaces. With over 15 years of experience in human resources and more than a decade of advocating on behalf of SHRM, I am pleased to share real-world challenges employers face when complying with the FLSA. At the time of its enactment in 1938, workplaces looked very different. The law's provisions are critical but outdated. To reach our workforce's full potential, SHRM believes in turning essential keys to modernizing this pivotal law, closing the workforce participation gap, and shaping the future of work. Opening doors that lead to innovation, economic growth, and more dynamic, competitive workforce. Modernization efforts must focus on federal and legislative solutions that prioritize clarity on which workers are covered, consistency in application, and compliance-oriented language. For the purposes of time, I will focus my oral testimony on the modernization efforts that will lean into our 3 C's: clarity, consistency, and compliance. Clarity. One issue is the lack of clear definitions, especially for terms essential like employee. It must also be clear whether an employee is exempt or non-exempt from overtime pay, as uncertainty increases the risk of misclassification. When the classification rules no longer match actual jobs, it's time for Congress and agencies to assist, as there are consequences to relying on outdated definitions or the assumption that a simple solution is to label all employees as non-exempt. From experience, some employees actually negotiate to be exempt because they value the associated flexibility and benefits that come from overtime exemption. Consistency. A real-world example of regulatory whiplash involves mortgage loan officers and qualification for the administrative exemption based on the duties analysis. This back and forth between agency and courts spanned nearly a decade before resolution at the Supreme Court. This uncertainty and others like it affect how employees work and businesses operate. Compliance. The unpredictability of FLSA regulations is a concern. When DOL attempted to raise salary thresholds for EAP employees in 2024, many businesses made adjustments, but when a federal court blocked the rule, they were left in limbo. Smaller businesses don't always have the dedicated legal resources to respond to shifting regulations. Additionally, the absence of clear federal standards has led to a patchwork of conflicting state mandates, making multi-state compliance more complex. To build a stronger, more resilient economy, we must unlock the full potential of the American workforce. This will only happen when we modernize workplace laws and policies, close the workforce participation gap, and shape the future of work. I urge the subcommittee to consider these reforms carefully. The FLSA is the foundation of U.S. labor law, but for it to remain effective, it must evolve. Thank you for the opportunity to share these insights, and I welcome any questions you may have.
Thank you. Next, I will recognize Mr. Stettner for your testimony.
Ranking Member Omar and other members of the subcommittee. A 13-year-old working the night shift cleaning the kill floor of a meatpacking plant. Working people putting in a 50-hour work week and getting paid for just a fraction of those hours. Mothers forced to choose between their children and their income when they're denied a place to pump at work. These are just some of the nightmare scenarios that Americans depend on the U.S. Department of Labor to prevent. Those protections are at risk. If Elon Musk's so-called Department of Governmental Efficiency gets its way and strips the DOL of its talent and capacity as it closes scores of DOL offices across the country. The truth is that 15,000 plus DOL employees, like I did in 2022, raised their hand to swear an oath to the Constitution to uphold the laws of Congress enacted to protect workers. They toil in every corner of the country to ensure that workers come home safe and alive at the end of their shift with the pay they've earned. Through consistent and targeted enforcement, the Biden administration recovered $1 billion in underpaid wages and damages. We should be increasing the budget of DOL and its enforcement powers to get at $50 billion in wage theft annually. But enforcement can only do so much. We need to change the law. The federal minimum wage of $7.25 has not been increased since July 2009, losing half of its purchasing power. Congress should pass the Raise the Wage Act of 2023, gradually raising the federal minimum wage to $17 an hour by 2028, benefiting an estimated 28 million workers. The minimum wage and salary threshold for overtime pay should be indexed to inflation so they never fall behind again. All Americans should be protected by the same federal minimum wage standards. Congress should eliminate the tip credit, which allows tip workers to be paid as little as $2.13 an hour, a level set in 1991. Eliminating the tip credit is the easiest way to relieve the administrative burden on workers and employers. It's also time to end the discriminatory provisions for a sub-minimum wage for workers with disability, as little as 25 cents per hour. DOL should cease issuance of 14C certificates, phasing out this program, which is already steeply declining in popularity. 14C should be replaced by programs to help disabled individuals find jobs in non-segregated environments, such as through the Transition to Competitive Integrated Employment Act of 2023. As one of the last actions of Acting Secretary Julie Su, DOL secured a $4 million settlement for children employed at Purdue poultry plants in dangerous jobs deboning and processing chicken. More is needed, like the Protect the Children Act. Over the last 15 years, employers and workers have had whiplash from changing regulations on independent contractors. Now is the time to return to court precedents. In 2024, DOL returned to the 6-factor test to analyze whether a worker is, as a matter of economic reality, economically dependent on an employer for work. This rule distinguishes between those individuals who are genuinely business with themselves and those who are employees and should be paid the minimum wage and overtime. Let me close by saying that the risk of DOGE and the Trump administration to the American worker is rising. President Trump inherited an economy that had added a record 16 million jobs during the Biden administration. Workers finally had leverage in the economy to see wage gains that actually outpaced inflation. Unions won record contracts, like a 25% increase for the UAW. Legislation like the CHIPS and Science Act catalyzed $1 trillion in private investment. But even this strong recovery ran up against powerful forces. The richest 1% of our country, people like Elon Musk, have captured an outsized share of national wealth. While 70% of Americans support unions, the erosion of labor law means that less than 1 in 10 can benefit. And women are paid only 83 cents for every dollar paid to a man, something we recognize today on Equal Pay Day. Let's stand on the side of workers and strengthen workers' rights, starting with modernizing the FLSA. Thank you, and I'm happy to answer any questions.
All right, and lastly, we will recognize Mr. Wolfson for your testimony.
Chairman McKenzie, Ranking Member Omar, and members of the subcommittee, it's an honor to testify today before this committee on ways to grow the nation's economy and free workers to earn by modernizing the Fair Labor Standards Act. I'd also like to recognize my daughter Hartwell, who's here with me today. My name is Jonathan Wolfson. I'm the Chief Legal Officer and Policy Director at the Cicero Institute. We're a think tank with the mission of identifying, developing, and advancing entrepreneurial solutions to public policy problems. Previously, I had the honor of leading the U.S. Department of Labor's Policy Office. In addition to my remarks submitted for the record, I'd like to focus on 2 key observations today. First is that legislation is a highly preferable way to go about amending the Fair Labor Standards Act. And secondly, there is some pending legislation before this subcommittee and other parts of this broader committee, which are ways to address the multiple difficulties facing today's workers. First, legislation is preferable to regulation. As everyone on this panel has said, there are things that the Department of Labor has done, and that has been done in order to try to assist workers or try to assist businesses. But ultimately, old and unclear Fair Labor Standards Act leaves many vital decisions to the regulators. For example, the definition of a tipped employee is any employee, under the statute, is any employee who receives more than $30 a month in tips. But on top of that, the U.S. Department of Labor has issued pages upon pages of regulations, and this leaves employers vulnerable to liability and investigation, not because they pay their worker the minimum wage as required under the law, but because they treat workers who spend less than a certain amount of time in a day performing work that the Wage and Hour Division deems to not be tipped work, a term that is not defined by the Fair Labor Standards Act. Unclear and outdated laws are not unique to Wage and Hour Division or the Department of Labor. So every year, regulatory agencies fill thousands of pages of the Federal Register, publish hundreds of regulations, and issue tens of thousands of opinions, interpretations, rulings, and other guidance. An ever-changing regulatory landscape is good for lawyers, but it doesn't help innovators innovate, businesses build, or workers to work. And it's bad for the citizens who pay more for everything that they buy and for the economy as a whole. It's time for Congress to act and improve the Fair Labor Standards Act rather than asking DOL to try to use its power to nibble around the edges. Congress can improve workers' lives with pending legislation. Modern workers and businesses are looking to Congress to bring the Fair Labor Standards Act into the 21st century. 3 bills that would include the Modern Worker Empowerment Act, which protects the large and growing number of self-employed workers who wish to remain self-employed. Some 72 million Americans are independent workers, and the vast majority of them prefer to be independent workers instead of employees. This law would reduce the risks from contracting with an independent worker and open more opportunities for work and flexibility for the self-employed worker by making it easier for everyone to identify who is an independent contractor. I would also recommend that this legislature consider providing some sort of opt-in provision for individual workers who might be interested in becoming independent workers as well. The Working Families Flexibility Act lets private sector employers choose comp time instead of overtime pay, just like government employees can. And the Modern Worker Security Act lets businesses contribute to boardable benefit accounts for independent workers without risking a determination that they've misclassified those workers as independent instead of employees. By protecting access to benefits, it supports independent workers while preserving the flexibility and autonomy of those workers. In conclusion, the Fair Labor Standards Act was created to protect workers, but as the economy and country have changed, many of those protections now block workers from the kinds of business relationships that they may themselves want. from benefits workers want that the Fair Labor Standards Act prohibits, or relationships workers hope to develop that trigger wage and hour scrutiny, a revised FLSA would benefit many of today's workers. Rather than relying on the administrative state to look for gaps in the statute to create rules that address today's challenges, Congress can and should act to bring the FLSA into the 21st century, promoting an employment law system that benefits workers, businesses, and consumers alike while helping our economy to grow. Thank you, and I'm grateful for the opportunity to be here and happy to answer any questions.
Thank you all. Under Committee Rule 9, we will now question witnesses under the 5-minute rule. I will recognize myself first and then our ranking member. So again, I'll be recognizing myself right now for 5 minutes. My 3 questions go to Ms. Bohan, Mr. Wolfson, and Ms. McCutcheon in that order. Ms. Bohan, you talked about seeking clarity, consistency, and compliance, making compliance easier. The 2024 overtime rule had a negative impact on each of those things, though. And as an HR director, I would love to hear your experience performing your duties, and can you describe the challenges that a small bank like yours would face if the federal government were to finalize an overtime standard that caused a large number of your workers to lose their exempt status?
Thank you, Mr. Chairman. Sure. So in my bank, I have about 101 employees, and funny enough, 3 years ago, before they hired me, the bank didn't have a dedicated HR staff. So these types of issues, if overtime threshold changed, would actually roll up to the corporate secretary and president of the bank. And they're not, they don't have formal education. They're not formally trained in HR things. They use an outside legal counsel, which surely they would have gotten the update and made the appropriate changes. But I'm mentioning that because so many small employers, they often are relying on an office manager to make these decisions. And are we counting on them to make the right call? So I hope that helped answer your question.
Absolutely. Thank you. Mr. Wolfson, BLS reported in November that 80% of independent contractors prefer their current work arrangement to actually being an employee. In my home state of Pennsylvania, we've seen bipartisan support for a program around portable benefits, a pilot program being offered by DoorDash. This program allows independent contractors across the Commonwealth to access health, retirement, paid leave, and other benefits without risking their independent contractor status. Do you have any recommendations on how this committee could increase access to portable benefits without triggering any unwanted worker classification changes?
Thank you, Mr. Chairman. Yes, I believe that the Modern Workers Security Act is a great step in that direction. It would make it very clear that when a worker wants to receive that sort of compensation in a form of a portable benefits payment, and that the business that they are interacting with on an independent basis wants to put that money into the account, that those dollars do not count toward a determination that that business is in fact their employer. Under the multi-factor test that the Wage and Hour Division is currently using under regulation for independent contracting, providing dollars in a form of a benefit, even if that's what the worker wants, even if that's what the business wants, that is one factor that the Wage and Hour Division could use to determine that a worker is in fact an employee. And so a lot of businesses are afraid to do that because the worker and the business don't want the employer-employee relationship. They want an independent relationship. And so this opens the door for that opportunity. It's something that Governor Shapiro and the Democrats and Republicans have worked together in Pennsylvania to do, and I think it's a really good idea for us to take national.
Great, thank you. My final question is for Ms. McCutcheon, as is the case with so many laws and regulations. Oftentimes the smallest of businesses are the ones that are the hardest hit. They just don't have the compliance ability, they don't have the resources. So in your view, what challenges have small businesses faced when dealing with FLSA compliance in recent years?
Well, they don't have lawyers, and they often don't have HR personnel, so they're relying on their advice generally from their accountants who just don't know the law. So it's not wage theft when they make a mistake. It's more like forgetting to run one of 50 items through the automatic checkout at a grocery store. It's an oops. And if they do the oops, right now, there's no settlement of claims, there's no waivers, there's no affirmative defense like there is under Title VII. So what happens is they get hit with a sudden huge bill, and it means bankruptcy. I've seen it. That's my lived experience.
All right, well, thank you to each of you for those responses to my opening questions. I now recognize the ranking member for the purpose of questioning the witnesses.
Thank you, Mr. Chairman. Due to the relentless cuts to the Department of Labor's capacity, the agency is struggling to fully enforce the laws already on the books and protect the rights of all workers. Thankfully, some laws, such as the FLSA, provide workers with the right to bring their claims in court themselves to recover lost wages and receive other remedies. However, with the rise of forced arbitration agreements, more and more workers are finding the courthouse doors closed to them. Mr. Stetner, can you explain how forced arbitration agreements harm workers and allow more law-breaking corporations to evade accountability for labor violations?
Sure. In recent years, forced arbitration agreements have expanded from business to consumers and workers. So that means when someone's rights are violated, they do not have the same ability to take that claim to court and get full restitution, and they're forced to go into arbitration.
President Trump's Project 2025 playbook calls for eliminating federal child labor rules that identify which jobs are too hazardous for children to be allowed to work. Mrs. Stetner, what do you think would be the consequences of removing rules that limit children from being employed in jobs that are dangerous workplaces?
You know, the simple answer is more children will get injured and maybe even die. There are a list of occupations that the Fair Labor Standards Act, through its regulations, based on research from Occupational Safety and Health, are too dangerous for children. And this is common sense things. Operating a saw in a meat processing plant is an example. Working in a coal mine. These are things that we don't want children in the 21st century to be forced to work in when they should be in school. It will mean that more children are going to be working at night and not being able to complete their homework. And unfortunately, we've seen this go in the wrong direction. Despite many criticisms of what the Biden administration did on child labor, wanting to enforce more, states are going in the opposite direction. We've had 30 states propose changes to child labor law, and 8 states actually roll back protections for children in workplaces that are unsafe. We shouldn't be going back to the 19th century. We should be allowing kids to learn and get the safe work experience as they build for their own future.
Thank you, Mr. Stetner. Mr. Chairman, I request unanimous consent to add to the record the Project 2025 proposal to weaken federal child labor rules and an article titled Trump's Early Actions Mirror Project 2025, the blueprint he once dismissed.
Without objection.
According to the New York Times, the resurgence of child labor appears to be linked, at least in part, to the exploitation of migrant children. Mr. Stetner, to what extent do you think the current administration's approach to immigration enforcement could affect child labor enforcement?
When you make it harder for immigrants to work lawfully with status, you're forcing themselves and unfortunately their children to go underground into the economy and work in dangerous conditions. Also, you're making a cloak of fear that's impacting immigrants and their willingness to complain when the law is being violated. That is enacted to protect them, but they're so worried about risking their immigration status that they won't complain. And lastly, if we see a return to policies like family separation, you're going to be leaving more children isolated with no other way to support themselves than working in very dangerous jobs, for example, cleaning at night in factories with dangerous chemicals and equipment.
Thank you, Mr. Stetner. Mr. Chairman, I hope we can all agree that children are the biggest assets of our nation, and that we will work to make sure child labor is enforced, and that we are doing everything to protect our children. I yield back.
Thank you. Next, we go to Chairman of the Full Committee, Mr. Wahlberg from Michigan.
Thank you, Mr. Chairman. Thank you for this hearing, and thanks to an excellent committee for being here. Mr. Wolfson, 25 years ago, the Worker Economic Opportunity Act amended the Fair Labor Standards Act to exempt certain types of equity compensation, such as employee stock options, from inclusion in overtime regular rate calculations. While this law appropriately exempted many types of compensation, it did not exempt restricted share units and other full value share awards. How should restricted share units be treated when it comes to calculating overtime pay?
Thank you, Mr. Chairman. I think that the concept that I would propose would be that any sort of compensation that is not based on you have to have worked this number of hours to get this amount of pay should not be calculated as part of an overtime calculation. And so ultimately, restricted stock options, those should all be included as items that we want to encourage employers to provide to their employees. And so including them as part of the overtime pay calculation reduces the likelihood that those employers are going to provide that to their employees. And so I think that we should treat it in the same way that we do a contribution to a pension plan or a contribution to a 401k, where we want to encourage employers to do this. And so we are not going to punish the employer when that worker then does overtime hours by making them figure out how much that's worth to a specific hour of time. We want to encourage those things. And so I think that that exemption should be much more broadly applied.
Which benefits, with that flexibility, the employee.
Absolutely.
In the long run, yeah.
Yes, it does.
Thank you. And welcome to your daughter as well. Ms. Bohan, community banks like the one you work for are an essential tool for small businesses to gain access to capital they sorely need. Yet federal regulations often make doing business more challenging for these banks. When an employee's classification is changed from exempt to non-exempt under FLSA, how does that affect payroll processes and other HR requirements for that employee?
Thank you. As I said in my oral testimony, some employees actually prefer an exemption because it comes with certain flexibility and benefits that are perceived by the employee. So when you're if an overtime threshold is changed and you're having to place an employee from exemption to non-exemption, it places, a burden on the timekeeping system.
And also impacts the feelings of the employee himself or herself as well.
Absolutely. I think that's one thing that I've seen and felt in the past year. We've had to change employee exemptions, and sometimes the employee doesn't quite understand why the exemptions, in my experience, why the exemption's being taken away. They feel like a certain career progression has been taken away from them.
They've been downgraded.
I would agree with that.
Benefits are important, but also perception is important as well. Thank you. Ms. McCutcheon, in your written testimony, you mentioned that the FLSA should allow private sector employees to choose compensatory time or comp time, which is extra paid time off work in lieu of receiving extra wages for overtime hours worked. Most government workers, let me state that again, most government workers are eligible to receive comp time, but FLSA prohibits the private sector from using comp time. Is this an oops? I love your technical term. How should a straightforward change like this benefit workers?
Well, this is an interesting one because unions and large employers actually have objected to the many comp time bills that have been proposed, but employees want it. They want more paid time off, and that's what you get with comp time. So this particular bill is something that benefits workers. So if you want to benefit workers, you have to allow them to choose cash or paid time off. And if you look at any of the Forbes or SHRM recent surveys about the types of benefits employees today are looking for, paid time off is high on the list.
That's the benefits of flexibility.
Absolutely.
Allows them to choose what they feel best about.
Right. They could work 4 days a week, and the prior week they might have to work 50 hours, and then the next week they can work 30. And that is the type of flexibility that employees really, really want today.
I'd love that for opening week of deer season. Thanks.
Well, in Pennsylvania, at Hershey, where I worked, we got that first day off.
Okay. Well, thank you for your testimony. My time has expired. I yield back.
Thank you. Next, we'll go to Mr. Takano from California.
Thank you, Mr. Chair. And thank you to witnesses for being here. Mr. Stetner, overtime pay is among the bedrock protections in the Fair Labor Standards Act. Where might an unscrupulous employer seek to exploit insufficient overtime protections? Where and how might that happen?
What we've seen, with, as we mentioned, the salary test and how it's moved around, you might seek to put someone right at that threshold, and then you're not paying them time and a half. And to the point that we were saying, around comp time, most Americans in salary jobs have paid time off. More workers should have paid time off. It doesn't mean you shouldn't be paid overtime for that week that you work 50 hours a week. Unfortunately, violations of overtime are the bulk of the damages in the wage and hour division protects. Just keep working some extra hours to finish the shift. Come in a little bit early to open up off the clock. All these things can be legal, but pay people the extra that they are entitled to. The goal of the law is to keep people working 40 hours a week so they can take care of themselves and take care of their families.
Well, thank you. Let me stress the importance of overtime pay. Let's take an example of an eligible worker who works 50 hours a week and makes $36,000 a year. Under the Obama and Biden overtime thresholds, that worker would get around $85 back in their pocket every week from overtime pay. That's over $4,400 a year that could go toward gas, groceries, rent, and a savings account and other expenses of everyday life. Mr. Stetner, can you tell me how much that same worker making $36,000 a year would make in overtime earnings under the Trump overtime threshold?
So basically they make zero in extra overtime because this flexibility means they're being asked to work at very low wages, nothing close to support a family, just because they've been classified wrongly or rightly as a salaried worker.
So under President Trump's overtime threshold, someone making $36,000 a year, which is not enough to live comfortably in any U.S. state, makes too much to qualify for overtime pay. So that worker would earn no overtime pay for additional hours worked. That's what you're saying.
That's correct.
Now, Mr. Stetner, how many U.S. workers would be deemed ineligible for overtime pay under the 2017 Trump rule, more or less?
It would have been more than 8 million workers would have lost either additional overtime pay or would have lost the protections that would have been afforded to them with the increase in the threshold.
8 million Americans would have lost any ability to earn overtime pay. So overtime hours worked would be uncompensated. 8.2 million workers were left behind once the Trump administration slashed the salary threshold. On the national level, that cost Americans $1.2 billion in lost wages. Mr. Stetner, what did the Trump overtime rule mean for the take-home pay of that worker making $36,000?
So you're cutting, thousands of dollars a year, money that family needed to meet basic expenses, education, transportation, paying your rent. At least in my family, that's why people worked overtime, either to make the bills or, like my brother-in-law, to be able to buy a boat. We wanted to buy something, put an extra overtime at the factory. That's what the union worker wants in America, and that's what all workers in America should be able to receive.
So when it comes to overtime compensation, what is more meaningful? A, being paid time and a half for hours worked, or B, being paid offered compensatory time off?
I think given the choice of being, you can have a day off to go to the game because you want to be with your son the next week, and getting overtime for the prior week, people would rather have the money in their pocket and the paid time off. I don't know why in this moment of record American profits and economic growth for the wealthy, we can't give people both their right to overtime pay and some paid time off.
So overtime protections, like other protections in the FLSA, represent the livelihoods of the American workers. They're not throwaway lines to use during campaign speeches as a gimmick. Americans deserve to be compensated fairly for their work, not conned out of the wages they earn through sweat and hard work by billionaires. After all, it is far harder to work a 50 to 60-hour week to feed your family than to spend 17 days of your first 3 months on the job golfing like our president has. I yield back.
Ms. Miller from Illinois.
Thank you, Chairman. Ms. McCutcheon, there is a serious shortage of home care services in this country, thanks largely to the Obama administration's 2013 home care regulation, which removed the long-standing Fair Labor Standards Act exemption for home care and companion care. Department of Labor estimated that the cost of home care services increased $1.6 billion during the 5 years after the rule went into effect. How can the FLSA work better for those who require home health care services?
Well, first of all, you could reintroduce and enact the bill that would restore the companionship service exemption to its original form back when I was wage and hour administrator in the Bush administration. This is an incredible, important issue to me. As we age, as more people retire, it is much better for people to be cared for in their home than to be institutionalized. But it's become so expensive that most working families cannot afford it if they have to pay overtime in addition to wages that are between $10 and $15 an hour for most home care workers. In addition, another problem is that the attack on independent contractors has really hurt the home care industry, particularly, for example, in Florida, where most home care workers are independent contractors, but the Department of Labor has been attacking their status. So everything that has been happening in the last 4 years has just been increasing the cost, and I'm afraid that working families seeking home care will have to go to an underground economy, hire people that are not employed by an agency that does that screens and screens them for past felonies, that provides insurance, and makes sure that their home care worker is safe in the homes of these families.
Thank you for shedding light on that. Ms. McCutcheon, also, as you note in your written testimony, the Fair Labor Standards Act is it's a nearly 87-year-old statute that desperately needs more clarity and simplicity. Can you elaborate on the differences between the ABC test and the common law standard as stated in the Modern Worker Empowerment Act for determining whether a worker is an employee or an independent contractor?
Yes, I'll answer that for both the ABC test and the current regulations of the Department of Labor. There is the proposed legislation is very simple. Who controls the work of the employee? If it's the worker, then the worker is an independent contractor. If it's an organization, then they're the employer. The ABC test is complicated. Nobody understands it. And even in California, where it was enacted into statute, there are over 50 exceptions and exemptions to it. The same thing with DOL's regulations. There's a last section that says, oh, and we'll consider any other factor that we find relevant, which makes it impossible from the beginning for people to understand whether they're independent contractors or whether they're employees, and for small businesses to understand that too. And if they don't understand, if they don't know the rules, then how can we expect them to get it right? We shouldn't call it wage theft. We should call it good people trying to follow the law, but they need to be told what the law is clearly and simply.
Well, one thing the government does well is complicate things, and we're excited to be in the majority now because we want to deregulate and make things work better. Mr. Wolfson, survey after survey shows that independent contractors prefer their current work arrangement to being an employee. The Biden administration's attempts to restrict independent contracting were an affront to independent contractors who made their preference clear. What can Congress and the Trump administration do to support and protect the independent workforce?
So I think there's three things that the legislature could look at. One is, as Ms. McCutcheon just mentioned, the Modern Worker Empowerment Act, which goes back to a standard of who's in control of the business and making that the determining factor. The second, as I alluded to in my oral testimony, is an attempt to allow certain workers to just opt into independent contractor status. There were some bills in prior legislatures that would allow that to happen, where a worker could simply opt in and say, I am in fact an independent worker, I understand the risks and benefits of that, and I'm going to do that and take that to the worker. The third thing is this Modern Worker Security Act, which would allow independent workers who, to your point, prefer this arrangement. Many of them may be married to someone who receives other benefits, but maybe they receive a health savings account with their spouse's employment, and they would like the business that they work with. Maybe they're in Pennsylvania and they work for DoorDash, and they'd like DoorDash to put some dollars into their health savings account. And that would allow them to do that without DoorDash having to count that person as an employee, and that protects the worker and the business and allows that transaction to happen.
Thank you, and I yield back.
Thank you, Mr. Cesar from Texas.
Thank you. So just to break down what my colleague from the Republican majority side of the aisle just advocated for is this bill that they're calling, Modern Worker Act that's going to help you. But really, at the end of the day, let's break down what it is the Republican majority wants to do to the American worker. They want to make it so that multi-billion-dollar companies don't have to pay their taxes. Instead, you, their employee, has to pay more in taxes. That's what their bill is all about. The Republican majority's bill that is attacking the labor standards that we won after the Great Depression under FDR. What they want is to say big multi-billion-dollar companies don't need to pay overtime to you. No, you need to work over 40 hours a week and not get paid anything extra for it. That's, at the end of the day, what this bill is all about. You're going to continue to hear under this Republican majority that they are for letting you be your own business owner. And if people are indeed independent contractors and small businesses, we should absolutely support them and support that. But what they want to do is to make it so that people who are employees of large corporations can instead be mislabeled as small business owners. But if you're just an employee being told where to go work, when to go work, and to just go do your job for a big corporation, call it a big corporation in big tech or a big corporation in big pharma or a big construction company, they want to be able to say you're your own business, so you pay the taxes instead of the big corporation. They want to say you're your own business, and so you don't get overtime protections. You just have to labor away until the job is done and get paid whatever you're told. So we should not buy some of these continued attacks on what workers won in the 1930s. I've seen this happen in my own district, where a group of workers that clearly basically ran all of YouTube music, and YouTube is a part of Google, wanted to organize into a union. And what we heard from Google was, these aren't our workers, even though this contractor that they work for only exists because of Google, only exists to run YouTube, but they wanted to deny these Austin, Texas-based workers their ability to negotiate for higher wages and higher pay. So don't buy this stuff about how we're trying to help small businesses, when really what this bill would do would make it so that the American worker cannot negotiate with gigantic corporations like Google. There are ways that we could support small businesses and independent workers. I have spent a lot of time working on how big agriculture is jacking up prices, not just at the grocery store for consumers, but is screwing over small businesses and small producers all over America. And so I have a bill that I thought we could get a lot of Republican support for, because many Republican small ranchers and small farmers and small producers and small processors are all for it, to say let's take on the gigantic companies that are paying less and less to small businesses for their product, and jacking up prices at the grocery store. We get almost no Republican support for that kind of proposal. But what we are seeing Republican support for is letting companies off for child labor in that same sector. So the Fair Labor Standards Act should actually be protected and supported and expanded for the American worker. And what I've heard this whole committee, I've been watching it from my office, came down here and watched some of the testimony from the other side of the aisle just a moment ago, is all about taking us to pre-1938 labor standards. That's what's in Project 2025. That's what's being executed right now, is making it easier to put children on the cutting room floor to do child labor jobs, not making sure our kids can have a good education and making sure their parents are paid well enough that they don't feel pressure to send their kids to go work in the factory or at the meatpacking plant illegally. We should be talking about giving people more overtime pay. But the bill that's being advocated for right before I got to talk here is to deny more and more Americans their own overtime pay. And in the moment where we're talking about taxes here in Congress, the Republican majority's tax bill is to give billionaires an enormous tax cut. You'll be hearing lots about it. But what people watching at home haven't heard enough about is this bill that is being pushed by the Republican majority to make it so that workers don't get paid for their overtime and then have to pay tons more in taxes because they get called independent contractors when they're really employees. So let's not fall for this scam. Let's actually support our small businesses and support workers by taking on big monopolies and making sure that working people and small businesses get to keep more of their money in their pockets, not less. Thank you, and I yield back.
Mr. Messmer from Indiana.
Thank you, Chairman and witnesses today. Ms. McCutcheon, you mentioned in your written testimony, overtime pay is based on an employee's regular rate of pay, not their hourly rate of pay. Unfortunately, regular rate calculations discourage businesses from offering benefits to employees, such as child care, elder care, and dependent care services. Could you go into more detail into how the Empowering Employer Child and Elder Care Solutions Act would help?
It would free employers to provide child care. For example, like the DOL does. They actually have an on-site child care facility where employees can drop off their kids. But guess what? They don't pay overtime on the value of that benefit. In the private sector, you have to. And the complexity is, how do you determine what the hourly value of full-time childcare is going to be for the employees and have your payroll system programmed correctly to include that in the regular rate? So by not allow, and it's not just childcare, right? To me, it's like you really want to help workers pay back their student loans? Make a change to that one section, and you can encourage employers to offer repayment of student loans as a very valued benefit. So this is a change that is great for workers, and it's the one thing I would really love to see happen, because it's childcare, elder care, college tuition, and repayment of student loans. Public transit subsidies, another benefit that federal employees get, as you all know, but which a private employer can't, because if they do it, they might get sued, they might have a huge overtime bill, it's hard to calculate what that overtime would be. So it has not been changed since 1949, 76 years ago. It's time to recognize that the benefits that we pay our employees today and that employees want is very, very different than in 1949.
Thank you. Are there any other legislative fixes needed to the FLSA that would stop discouraging businesses from offering these benefits?
Well, I would also suggest that we need to put new provisions in the FLSA to allow businesses who make mistakes to correct them, to self-audit and self-correct. The FLSA is different from any other federal employment law. There's no affirmative defenses like in Title VII, right? So let's have an affirmative defense to encourage employers to have a wage and hour policy, to have complaint procedures, to investigate those complaints, and to pay back wages when they're due. Let's bring back that PAID program, which I used during the first Trump administration to bring millions of dollars of back wages to workers under the PAID program. Let's allow private settlement of claims and private waivers, just like under any other federal employment law. Then employers would be less scared to make those mistakes.
Thank you. Ms. Bowen, the Biden administration's overtime rule would have cost businesses roughly $18.8 billion, according to an estimate from the American Action Forum. Those increased compliance costs will have to come from somewhere within the businesses themselves. What decisions are businesses forced to make when such large regulatory burden is enacted at the federal level?
Thank you, Congressman. I think, it can be hard, but, one thing you look at every year is the need for labor. So you can be creative in perhaps getting more done with less people.
Okay. Thank you. Mr. Wolfson, non-exempt or hourly workers are often want to participate in professional development opportunities outside of regular work hours, but FLSA's compensable time requirements restrict their ability to take advantage of these opportunities. Do you believe that non-exempt workers should have the same ability under the FLSA to attend voluntary training as their exempt or salaried counterparts do?
Yes, Congressman. I think that the worker who would like to enhance their skills and upskill so that they can move on to additional jobs in their career should be encouraged to do so. And many businesses want to train their workers to do another thing. There might be professional development opportunities for that worker. And if they are an exempt worker from overtime, then it's really clear that those workers are doing those activities. And to the chairman's question earlier, many workers want that status of being able to move up, but by requiring employers to count provision of additional training in the off hours as hours worked, or even at the training costs as part of the overtime calculation, businesses are less inclined to offer that, which is going to further divide the exempt worker from the non-exempt worker and make it harder for that non-exempt worker to move up in their career in that job. And so I think it's really important that the Fair Labor Standards Act recognize that, and all of these changes recognize that the employer and the worker do have the opportunity to negotiate, and we want to give the worker the ability to ask for the things they want and the employer to provide that if that's in everyone's best interest. Thank you.
I yield back my time.
Thank you, sir. Next up, my fellow Pennsylvanian, Ms. Lee from Pennsylvania.
Thank you, Mr. Chairman. I do want to say that it is a little interesting of a choice to be holding a hearing on dismantling equal protections for equal pay on Equal Pay Day. But we need equal pay day because wage laws in our country were never designed to be fair. From the very beginning, they have reflected the choices that we make, choices about who we value, whose labor we under or fairly pay, and who we leave behind. And for generations, black workers, brown workers, women, and especially black women have been trapped at the bottom of that hierarchy. We see that clearly in today's economy, where the people holding up entire industries, nursing home aides, restaurant servers, grocery store workers are often the lowest paid. Those are overwhelmingly women. These are disproportionately women of color, and they are working full-time jobs that still don't cover the rent, food, childcare, their basic needs. Mr. Stetner, in your testimony, you shared a report from the Institute for Women's Policy Research finding that women earn about 83 cents on the dollar compared to men, and for black women, of course, it's closer to 67 cents. For Latinas, closer to 58 cents on the dollar compared to white men. So when we talk about modernizing wage laws, we can't afford to leave this context out. As long as skyrocketing corporate profits and poverty wages exist side by side in our country, our communities will continue to suffer needlessly. So we've grown accustomed to the idea that some people are bound to be wealthy and others are bound to live paycheck by paycheck. And the billionaires in the White House are counting on us staying accustomed to that idea. This should come as no surprise, given that our country and my home state of Pennsylvania has been stuck at a minimum wage of $7.25 for the last 16 years. Mr. Senator, do you believe that $7.25 is enough for a worker to take care of their families? And will we ever address the wage inequity if that remains the federal wage floor?
The $7.25 minimum wage, I think everyone with common sense can know, even on a full-time job, you won't be able to support yourself. And that's beside that most people are trying to even support a family on that little bit amount of money per week.
So my Democratic colleagues and I have supported legislation to raise the minimum wage and institute automatic increases based on the cost of living. How will those types of proposals benefit working people?
So it means that working people can know each year, as the price of living goes up, that their wages will go up. In many parts of the country, January 1st is a celebration day because states have put indexing in place. And once Congress does that, we won't have to be debating and keeping as a token or a chip of whether the minimum wage for the American worker goes up each year.
Thank you. And I can tell you from my time working on the fight for 15 that 15 is not enough. We need a wage floor that reflects the real cost of living. Workers shouldn't have to cobble together multiple jobs just to stay afloat. We also need to talk about the sub-minimum wage. While Republicans in the House are fighting to give over $4.5 trillion in tax breaks to billionaires and large corporations, tens of thousands of workers with disabilities are being paid as little as 25 cents an hour. Mr. Stetner, can you start by explaining the legal basis of separate treatment for workers by disability?
Section 14C of the FLSA allows people with disabilities to work in what are called typically sheltered workplaces. And it's the employer that gets to see, well, based on your ability, how much can I pay you? That's why people have been paid as little as 25 cents per hour. Only certain workplaces are allowed to operate in this way under Section 14C through certificates. People with disabilities do not want to work in segregated workplaces. They want to live and work in their community. That's why the number of certificates have gone down each year to just only about 500 across the country, and many states are already outlawing this practice. The Department of Labor has done the right step. We've issued a proposed rule to cease issuing any more certificates. And the idea that the Trump administration won't follow through and rather would say, let's put more workers with disabilities in this discriminatory environment in 2025 is something it's hard to contemplate.
And thank you. And just in the interest of time, I think there's so much more that we can talk about. The sub-minimum wage, right? Separate from the wages for those workers with disabilities, but those workers who work in service industries, restaurant workers, folks who we know live off of tipped wages where they see their employer able to shift the burden to the consumer. But we also know that those jobs are more likely to come with sexual and workplace harassment. We haven't talked about the benefits cliff, where we know so many folks who work for lower wages recognize the simple math, that if they get too little of an increase, but not enough, then they would lose the benefits that keep them in their homes or keep them with health care. Those are all issues that we have to take much more seriously. So I thank you all so much for your time and for allowing me to join today, and I yield back.
Mr. Grothman from Wisconsin.
Thank you. Interesting point. In addition to pointing out the benefits cliff, the current welfare programs discourage people from working, and I guess because some people like them dependent on the government. We should also point out that they strongly discourage people from getting married, because obviously if you're a single parent and you marry somebody with an average income, all of a sudden you're no longer in poverty and you could lose $25,000 a year in benefits. So I guess I'll ask you guys, that's not exactly the topic, but since it was brought up, is there a strong marriage penalty in society that causes people to perhaps not want to be married and lose all their federal benefits? Would either Mrs. Bohan or Ms. McCutcheon care to tackle that?
Thank you, Congressman. That's something I haven't really thought too much about,
okay.
so I probably can't answer in detail.
Well, we'll just go with common sense here, right? When you have a bag full of $30,000 worth of benefits, daycare benefits, free low-income housing, free food stamps, earned income tax credit or whatnot, and you get married and you're no longer eligible for those benefits, do you think it causes less marriages in our society? There's like a $25,000 penalty for being married.
Let me take that up. Absolutely. And this particularly goes to, and it's very similar with Section 14, which, by the way, is in the FLSA, so the DOL can't just write it out of the FLSA because they're not Congress. But when I was wage and hour administrator and I recovered back wages for 14C violations, the families came to me and say, we don't want all those back wages in one lump sum because we are going to lose other federal and state benefits if our son or daughter gets that huge chunk of back wages. So getting rid of 14C and other things in the federal can discourage work and marriage.
Yeah. Now, Mr. Stetner, I'm kind of appalled at your hostility towards 14C. So people here understand if you have certain disabilities, spina bifida, Down syndrome, quadriplegic even, in order to give you the benefit of work and make a little extra money. Usually these people are on SSI for most of their income. They are allowed to work for under minimum wage, okay? I wondered how, and when I love to tour these facilities, it makes you feel really good to see these incredibly happy people who, at first blush, life has dealt kind of a tough situation, but they're working for $2 an hour, $3 an hour, enough to work on their own, enough to be like their siblings, have a job, maybe buy some clothes, buy some gifts for people, what have you. How many 14C certificate workplaces have you seen in the last few years?
As the president of the Autism Society of America of Maryland, taking care of my daughter as autism, what we've done is we've helped people with autism get good jobs in the community, working in a manufacturing plant, working at a Defense Intelligence Agency in Northrop Grumman. We can do better in 2025 than segregating people with disabilities into sheltered workplaces.
Well,
let's do better with things like the transition to Integrated Competitive Employment Act, which would allow states and communities to give the supports, coaching, and otherwise, so people can actually work in their own local restaurants, their own local bakeries, where I buy my baked goods. They don't need to be in segregated workplaces.
Okay, what I'm asking is, have you talked to these folks? Whenever I tour my facilities to take advantage of 14C, I am always impressed on how happy the people are who are there. They're able to work there for an extended period of time and establish new friendships, which is also important for these people, because frequently if you are that disabled, your parents have to worry, are you going to have any friends outside your parents? Here you have friends that last for years and years and years. Don't you feel, and there are people who can work in a goal of all these workshops is to have people work outside, but some people can and some people can't. And that would be obvious to anybody who toured them, that the vast majority of people here are happy and that the vast majority of people working on the floor probably couldn't find somewhere to work in the community. Again, I'll ask you, have you specifically toured these places to talk to the employees to see whether they're happy or unhappy?
Most people with disabilities and their parents want them to work and contribute to themselves.
I'll just cut you off. I'm out of time, but that is just plain not true.
Mr. Kiley from California.
Thank you, Mr. Chair. Mr. Wolfson, you've done some outstanding work on supporting independent workers, freelancers who comprise about a third of the American population at this point. That number's fairly likely to grow. I think it's very important that right now we take advantage of the opportunity to put protections for independent workers into statute, which is why I've introduced the Modern Worker Empowerment Act, Modern Worker Security Act, which I know you mentioned in your introduction. So before getting into that, though, would you mind just giving us a brief recap of the effect that the attacks on independent workers have had in California with AB 5, as your institute has shown, and then the threat posed by the Biden administration's effort to sort of mimic that legislation?
Mr. Chairman, thank you. I think the key thing to remember is after California passed AB 5, a number of businesses, including businesses that no one would consider the businesses that Mr. Sadar is calling or abusing their workers. The New York Times told photographers, freelance writers in California they wouldn't work with them anymore because they didn't want to have to provide the benefits that California was going to require them to provide those workers for just a small amount of work. And so people in the film industry, people in lots of industries who are making significant sums of money lost their positions. And so people in your district were losing their jobs. Truckers were told you are no longer going to be allowed to move products from the ports out of the ports, including when we had massive port challenges of moving goods during COVID. We had people who were unable to move those goods because those workers knew the risks and the benefits that they were taking upon themselves in starting the business. And then California's legislature came in And they said, we're not going to allow you to make that decision anymore. We're going to protect you from yourself. We're going to protect you from making money because we think we know better what your relationship with another business ought to look like. And the reality is we don't do that in most places in America. We would allow an individual who wants to contract with someone to do work at their house to hire who they choose to work with and to come to an arrangement for how much that's going to cost. If suddenly anybody who was coming to do HVAC work at my house, I had to provide them with, I was legally required to provide them with the same employee benefits that workers who work with me at the Cicero Institute receive from our organization, that would change the entire calculus of how much I'm willing to pay them, what I'm willing to pay them, what I'm willing to do. And we need to allow people to have those interactions. And so I thank you for proposing those bills. I think both of those bills will go a long way toward helping workers in states across the country who want to be independent workers to be able to be independent workers, to work with those businesses and not discourage those businesses from hiring them.
Absolutely. And so one of the bills seeks to actually provide a clear sort of common law-based standard for being an independent worker, which is what has prevailed in this country for a very long time. You know, that, of course, the Trump administration had a similar standard in its first instantiation, which this legislation essentially seeks to restore, but to do so in a durable way so that we don't have the uncertainty that comes with the new administration coming in, potentially changing the rules. But then the other bill deals with this topic of portable benefits that you've written a lot about. So could you just tell us a little more about what those are and why under current law sometimes employers are, or I should say hiring entities are discouraged from offering them to independent workers?
Yeah, so as Ms. McCutcheon mentioned, one of the factors at the very end of the Wage and Hour Division's rule on independent contracting, that's the current regulation that's obviously being challenged right now, but the one from the last administration explicitly says we can consider whatever additional factors we want to. But one of the factors that has traditionally been considered in deciding whether a worker is an employee or not is whether there's benefits that are provided to those workers. And your bill would explicitly say that the mere provision of access to benefits, if that is the arrangement that the worker and the hiring entity want to do, is not going to be considered as a factor in determining whether that person's an employee. So I'll give you an example. If an individual worker has a spouse who has, as I mentioned earlier, a health savings account or a retirement account, and their employer does not fill the entire account, but they would prefer to have the tax preferences of having those dollars put into the health savings account. Maybe they recognize that they can actually save tax dollars by putting it in the account from the business directly, and then they don't have any of the business taxes that Mr. Cesar is worried about. In those circumstances, right now, if they put that money in, if the business puts money into the health savings account, so you have a business in town that asks someone to do computer repair for them on an independent basis, they put money in that health savings account, right now, that could be a factor that the Labor Department considers employment, even though the worker will benefit by getting the tax preferences of putting that money directly into the health savings account. And so that's what the portable benefits concept is allow workers to have an arrangement with the hiring entity to put dollars into those accounts so that the worker can get the benefits from those types of retirement and other types of savings accounts. And the business can interact in the relationship in the best way that gives both the worker and the business the relationship that they want.
Yeah, it's a total win-win. I mean, under current law, the dynamic you describe is sort of a no good deed goes unpunished, whereas if you want to provide this level of security and benefits to an independent worker, then that might cause you know, the entire relationship to be recharacterized in a way that's in neither the interest of the hiring entity or of the worker. And so what we're trying to do is provide a safe harbor to prevent that from happening. Thanks so much for your work on this topic. I yield back.
Mr. Owens from Utah.
Thank you. Ms. McCutcheon, in 2018, President Trump signed an executive order to exempt seasonal outdoor recreational businesses operating on federal lands from certain FLSA requirements, such as overtime. These businesses offer multi-day trips that quickly hit the 40-hour mark to trigger an overtime requirements. The executive order stated that unless the exemptions was in place, federal regulations would threaten to raise significantly the cost of guided hikes and tours on federal lands, preventing many visitors from enjoying this great experience. With your background at the Wage and Hour Division and private practice, can you explain what relief this executive order provided for these businesses?
Yes, thank you for the question. It's federal, that was great, but it's also any sort of business that does tours, whether on federal lands or not, because, you know, when you're doing an overnight hike, which Americans love to do, I live now in the foothills of the Great Smoky Mountains, We love to do those overnight hikes, but if you have an employee who's on federal land and doing those overnight hikes, you're going to hit over 40 hours very, very quickly because you're basically on duty 24 hours. So a 2-day trip gets you into overtime. And that means more costs, and that means charging Americans more to go on those trips. So again, it's a win-win for America because more people get to enjoy our national parks and our national lands at a much lower cost.
And I would imagine also negatively impact a small business owner trying to run a business because of the extra cost that's demanded at this point.
And that is what most of these businesses are small independent businesses. I was just looking up the other day to rent an e-bike to go on Cades Cove Drive in the Great Smoky Mountains on non-car day. And that's a small business, right? So the people who are providing this work are small businesses who, by the way, this gets put to the whole wage theft thing, they don't know that they're violating the law. And if they don't know and they get hit with the deal of investigation or private litigation, they can be bankrupted because they're just trying, no good deed goes unpunished.
I'm going to kind of wrap up with just one last statement, but I'll just say this. It's time for us now to truly protect the small business owners. That powers our middle class, which is where our culture comes from. So I applaud the business owners to take this risk, go out, and we're going to make sure we do everything we can to protect them. Later this spring, I will be introducing an outdoor recreational outfitting and guiding act. This would exempt eligible employees from overtime limits in order to support and expand the outdoor tourism industry. I will encourage more Americans to experience the natural beauty of our nation that has to offer, and this bill will be a step in the right direction to create a long-term solution for outfitters and guides that would have been unfairly affected by this onerous requirement of the Fair Labor Standard Act. So thank you, Chairman, and now you're back.
All right, the ranking member of the full committee, Mr. Scott from Virginia.
Thank you, Mr. Chairman. Mr. Stetner, a lot has been said about workers wanting to be independent contractors. And let me just check. If you're an employee, you get minimum wage. You're entitled to minimum wage. Is that right? And if you're an independent contractor, you're not.
That's correct.
If you're an employee, you're entitled to overtime. And if you're an independent contractor, you're not.
That's correct.
If you're an employee, if you lose your job through no fault of your own, you're entitled to unemployment compensation.
That's correct.
And if you're an independent contractor, you're not. If you get hurt on the job, if you're an employee, you get workers' comp.
That's correct.
And if you're an independent contractor, you don't.
That's correct.
If you're an employee, your employer pays part of your Social Security responsibility.
That's correct.
And if you're an independent contractor, you have to pay it all yourself.
You pay the whole thing.
Your safe workplace under OSHA, you're entitled to a safe workplace under OSHA. If you're an employee, it doesn't apply to independent contractors.
For the most case, yes.
If if the employees have health and pension benefits, if you're an employee, you get those. If you're an independent contractor, you don't.
That's correct.
And we just heard if you spend hours in training, if you're an independent contractor, you get to volunteer. If you're an employee, you actually get paid for the time you spent in that kind of training. Is that right?
That's correct.
What are the advantages? So you lose all that. What are the advantages of being an independent contractor?
You know, no one, probably on this committee, disputes that if you are genuinely in business for yourself to make profit, you should be an independent contractor. But in the world that I live in, I've seen janitors and said, well, your condition of working to clean this business building in Boston is to pay for a franchise and get paid less than you would have got paid in the minimum wage. In the world that I live in, we found dishwashers in a restaurant in Minnesota who were given the privilege of washing dishes because they had a business and that was their skill. These don't make common sense. So what these workers are losing when businesses call them independent contractors, they're losing their right to the minimum wage and overtime.
And so the employer saves a lot of money when he misclassifies people as independent contractors. And so do workers, in your opinion, want to be independent contractors, or are they relegated to be independent contractors because the businesses only will hire them if they call themselves and agree to be independent contractors so the businesses can avoid the costs?
There are just so many myriad examples of businesses misclassifying their workers as independent contractors, and those workers really having no choice, and it's really to cut corners and to increase their profits.
The Department of Labor is going through staffing reductions. Economic Policy Institute suggests that more than $50 billion could be stolen from workers through wage theft. What would the impact of reductions at the wage and hour division have on the ability to recover stolen wages for workers that have earned them?
We have just about one investigator for every 250,000 workers in the economy. Already, DOJ has canceled leases for offices across the country. That means that the few investigators we have are going to have to drive hundreds of miles to investigate. They're not going to be there to answer calls from employers seeking to comply or workers seeking to complain. So it's going to increase the amount of wage theft that goes unchecked in our economy.
We've had headlines about a recent dip in the stock market. We also know that under President Biden, the economy created 16.2 million jobs, a record for a single term, and more jobs than any Republican president created, whether they served 4 or 8 years. Unemployment rate fell. He was the first, President Biden was the first president on record not to have a single month of seasonally adjusted job loss. What indicators are you watching to see if the Trump administration is performing from an economic perspective?
Well, we're already seeing consumer sentiment dropping, business sentiment dropping, and we're waiting for the other shoe to drop, which would be people losing their jobs with the rise of the unemployment claims.
Thank you, Mr. Chairman. You're back.
Thank you to the ranking member of the full committee. I'd like to recognize the ranking member of the subcommittee now for her closing remarks.
Thank you, Mr. Chairman. Thank you once again to our witnesses for speaking with us today. For far too long, the American economy has not properly served workers who uplift it. Instead, the wealthy and well-connected benefit from the labor of millions of working Americans, and now the ultra-wealthy oligarchs like Elon Musk are trying to tip the scales even further in their own favor at the expense of working families. As we sit here today, Republicans' disastrous economy and labor policies are threatening the future of millions of workers across America. DOJ has stripped the Department of Labor of critical resources and fired countless federal workers, and the department has failed to answer basic questions to inform us and the American public about the extent of these cuts. To top it off, the Trump administration appears poised to tank the strong economy they inherited. The Fair Labor Standards Act was written at a time when workers were similarly threatened. Yet at this critical moment where workers' futures hang in the balance, we absolutely cannot dismantle or diminish the FLSA and further strip workers of their protection. Committee Democrats have a vision for the economy in which our labor laws deliver for workers. We must build on the FLSA to increase the minimum wage, combat wage theft, eliminate the subminimum wage, and increase penalties for child labor violations. I hope that we can continue to have this important conversation to discuss how Congress can strengthen this landmark legislation. The FLSA must always prioritize the health and safety of workers. Thank you, and I yield back.
Thank you to the ranking member, and thank you to all of our witnesses again for taking the time to join us today with this subcommittee. This discussion, again, it's not only our first subcommittee hearing of this Congress, but it's also just the start of our work to update and modernize FLSA. It's an important piece of legislation for employers and employees all across this country, and we want to continue to encourage our businesses to do the right thing, make sure that they can expand and grow right here in the United States of America by offering good-paying jobs, family-sustaining wages, and all of the products and services that so many Americans enjoy in their daily lives. This law has not been updated significantly in the way that it should be for 87 years. And so we need to do that to help employees. Employees were devastated during the Biden administration with rising inflation that did not keep pace with wage growth. There was no way that was going to be possible because inflation was so out of control from the massive spending that was going on here in Washington, D.C. We all know that employees were devastated by Bidenflation. So what can we do to help our workers? We can innovate. We can modernize our labor laws to help them. Our Republican members have put forward a series of legislation that I think is going to be something that we should really consider to help as we go forward. And Representative Kiley, he has the Modern Worker Empowerment Act, is one possible option to help clear up worker classification issues and clear out decades of litigation and confusion which have frustrated both businesses and workers. We also have Mr. Messmer's proposed legislation around empowering employer Child and Elder Care Solutions Act. We know that far too many working families right now are struggling with the cost of child care and elder care as well, and so this is something that could help potentially in those situations. Finally, we should also consider codifying programs of the Department of Labor, such as the Payroll Audit Independent Determination or PAID program. Mr. Grothman's bill, the Ensuring Workers Get Paid Act, could be one potential avenue to pursue. Finally, the topic of migrant children and all children across our country, making sure that they are safe, is something that was brought up in this hearing. And I couldn't agree with you more. That is something that we want to make sure that child labor is stopped in its tracks here in the United States of America. For far too long, we thought this was a dead issue, only to see its resurgence during the Biden administration. We saw the New York Times, as was mentioned, put out a piece that said, as migrant children were put to work, the U.S. ignored warnings. The White House and federal agencies were repeatedly alerted to signs of children at risk. The warnings were ignored or missed. That's what the Biden administration did to children and migrant children right here in the United States of America. A total disgrace. So it is up to the Trump administration to clean up that mess of the Biden administration and make sure that we protect all workers, all employers, and most certainly all children in this country. So I want to thank our panelists again for testifying. I'd like to thank everybody who asked questions, and hopefully we can work together to actually improve the lives of all Americans throughout this Congress. Without objection, there will be no further business, and the subcommittee stands adjourned. Thank you.